Okay, anyway, thank you so much for having me, Yvonne and Farah. I should start with that. A very kind introduction. I didn't recognize the person you were talking about, but I suppose that's what the profile was given to you all, but thank you very much. Okay, I'm not terribly certain as to whether the written advocacy portion only applies to court work or arbitration. So my talk, everyone, will actually encapsulate both. I will address what courts expect and do, but I also will tell you what arbitration entails. At least that will be a little bit different than, hopefully a little bit different from the other speakers as you go along the day. Okay, so maybe I could just know from Yvonne or Farah, are these all just university students for now? Yes.
Yes.
Okay, so a little bit of a background. I actually did my first arbitration as a pupil, means right after bar school when I came home to Malaysia, then we started an arbitration. So even as a first year or a pupil, I was already doing drafting submissions, or which is what I would assume the understanding of written advocacy is, which is written submissions. I was already a part of the team that did that, on top of course, the court work. And I hope, although there's an absence of slides or materials in front of you, you still understand and get where I'm coming from. If whatever I say don't make sense, or if I don't sound clear to you, just let me know. All right, can we start, everyone? Great. Okay, so I'm assuming all of you at some point, if not, will eventually start your pupillage and you will become lawyers. If not, that's fine. If you do, that's great. So a lot of people emphasize on the importance of oral advocacy. I'm one of those. I think it's very important to be able to speak and deliver and articulate your arguments to judges or arbitrators or adjudicators as well. So written advocacy, in my mind, is not just court work. There's, like I said, arbitration, adjudication, and whatnot. And many a times people don't remember what it is that you're trying to do, that people always assume lawyers are people who stand up and talk. Yes, that's it. But the real practical application of advocacy also comes through written work. Because I give you a good example. If you were to have a matter in court, let's say High Court, and you appeal, what goes into the record of appeal that the Court of Appeal looks at, part of it is your written submissions. Because oral submissions are not recorded per se, because they're just things you submit in court, in open court before a judge. Of course, if you get a transcript of that notes of proceedings, it's there. Sometimes they aren't such notes of proceedings. Some courts don't have it, or it's not required. Let's say for simple matters like interlocutory matters, it may not be there. So some of your arguments, which are stronger, may not be there. That's why the two factions of counsel who believe that everything you want to say must be written down, so that when it goes on an appeal or a leave application, it's there. Some of them believe that you can improvise it as you stand, which is again another very great feat of an advocate, because you're able to think on your feet and deliver what it is. But personally, I think it's good to strike a balance between both, to actually try and endeavor to put all your written arguments down, at least it's there, and also be able to deliver it orally. Okay, back to today's topic is, I guess this is a talk about written advocacy. I think it's very important to have in your mind a framework. That's the first thing. If anyone's taking notes, the first thing is framework. Have an idea of what you want to submit upon. I generally call it a roadmap. Like either it is there's an introduction, and then these are the issues, these are the principles of law, these are my arguments, have those down. And this will help you navigate your mind as you draft. Because if you don't have a roadmap or a framework, you're just drafting in the dark. You're just knocking out words, and as it comes into your head, you're just saying it. There's no thought process, there is no planning, and you're just going to waste your time, and there's no flow. So for me, framework is very, very important, because it acts as like, like I said, it acts as what it says, a roadmap. It guides you as you go along. And then you will see, let's say, for example, you're doing written submissions for a hearing, and you have 4 simple application like a summary judgment, the law of summary judgment. what are your arguments against if you're resisting it? So you say these are there are triable issues, then you set down the law on it, tried law case. I have a practice that I try and apply, and I can share that with you now when I draft, but I'm not saying that's the only way, because the beauty of being an advocate is that you must be flexible. Not every case can just be done in the same way. There are no two same submissions, because there are two different ways of arguing everything. If not, you won't have so many lawyers. So always set out the facts, set out the law, apply the law to your facts. For example, once you set out the background facts, these are the salient or what you want to call the vital background facts. Then apply the principles of law. For example, like I said, summary judgment, there are no triable issues. Therefore, does not warrant summary judgment. You must go for trial. Then you must take those facts and say, so these are the facts. I say A, or my client says A, he's plaintiff. He says that A did not pay B those funds, but B and the defendant said, no, B did in fact pay. So that's a triable issue. Whether or not such monies were paid or not becomes an issue, right? Then you say, so these are the list of triable issues. Applying the law where there are triable issues, this must then go towards trial, and it cannot be dismissed summarily. So law facts, law, apply law to the facts, and then you come to a conclusion. You get me? So framework. So once you have a framework, and within that you subhead inside how you're going to argue it, there's a lot of flow in your written submissions. A very well drafted piece of written submission will guide towards, sometimes certain judges are not keen on hearing you for 45 minutes. They just say, okay, like in the Court of Appeal, the federal court, they say, we give you 15 minutes, 20 minutes, convinces. To be fair, from experience, even 20 minutes, you cannot convince them otherwise, whether you should win or the other side should lose, then you're probably going to lose, because they don't have a whole day to sit there and listen to you like a high court judge would, or a sessions court judge, or a magistrate court judge would, So then you have to decide then there is counsel on your feet that, okay, I stand by my written submissions, because everything I have to say is inside there. It's inside this document, this 35-pager, this 45-pager. So now that I'm talking about pages, please don't write 45 pages for everything or 100. I've seen submissions in 199 pages, and I'm like, okay. Then the judges will ask you for executive summaries. So again, you're then doing extra work, right? So, but then the question I always ask myself, if I could have said it in 35 pages, why did we say in 70 pages? I mean, it's not like you're reading a novel, right? So why are you writing so much? But I accept that sometimes, like in arbitrations or very heavy litigation, or there are like a lot of issues, then you do tend to draft more voluminous submissions. But therefore, it would then guide that you go to an executive summary. I'll come to that later. So everyone's clear? The first thing is have a framework. If you, so that you're not shooting off your hips and in the dark and not knowing what you're saying, it guides you. It becomes like this a little frame that says, okay, this is what I want to say. And it also serves to assist yourself to think that, oh, have I covered everything? Or like it can be eventually, what I like to do is I have a table of contents. Right after my cover, I have a table of contents. So anybody who's looking at a particular issue will just go to that. Oh, this is the page, it deals with this. So I find that it guides. The second thing I will go to is what we call signposting, having headers. So for example, later I'll just show you briefly a sample of a written submissions I've done. What happened would be, you have an introduction. Thereafter, you would have your background facts, but I do like something right before that. So I'm just going to speak to you about it. So it's very good to have an introduction, what you call an executive summary. The executive summary is actually just a 3-4 paragraph sort of part of your submissions that says, this is the issue, this is my general argument, this is how we deal with it. So anyone who doesn't want, I don't know, are you all familiar with the words too long, don't read? So if you don't want to do the TLDR, just go there. It says everything I have to say. If you're interested, go to the relevant sections and expand. Like if I'm saying no summary judgment for these reasons, 1, 2, 3, pop, 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 pop. Why? conclusion Y, conclusion Y, conclusion. If you're interested in my first issue, go immediately to that portion of my actual written submission and have a look at it. The law would be there, the explanation of the law would be there, the analysis would be there, arguments for and against would be there. You get me? So it's like, if you want, this is just a snapshot. And I find it helps because some judges don't have the time and patience to look, okay, what? Even you yourself also probably be like, if I can say it in 5 words, say it 5 words. And then I will go on to background facts, then I'll go into the law, then like I said, each issue, then I'll break down to issues. When I say signposting, I hope, I'll show you a sample, like I said, Charlie. But so it literally says issue 1, this is the issue. And then you deal with it, then you move on to issue 2. So it's everyone that's reading it, it's not 35 pages of just words after words after words. You don't even know where's the ending, where's the start, and what issues are you addressing. You know, it helps, it guides. Like within the roadmap, it's like an arrow that tells you how to go along and to get to your destination. Okay, so first thing, framework, then the emphasis on executive summary, and then the actual signposting. So even the reader that reads it will enjoy your written advocacy or written submission, because it's like, oh, now she's concluded the first issue. That's her position, okay, or his position. He and she's moving the second version. You know, it's like you cut off and then you move on. You cut off and then you move on. So it flows really well. Then the third thing I would emphasize is less is more. Don't say more than is necessary. Just because you write 15 sentences on an issue does not mean it becomes more convincing. You understand? And I try to avoid, so I've now moved on to actual drafting. Say what you can say in the shortest sentences you can say, with clarity, precision, and good grammar. That is it. And that is actually very difficult. You think to say something in 15 words, think so after I'm going to pick one person to give me a sample of a sentence, and I'll pick another person to try and shorten it, and you realize what I'm trying to say. Felicia Jane, come, try say something. Okay, I'll give you a set of facts now. I'll say it, and then you put in a sentence, okay? Can? And then
okay.
Brandon, you will then shorten it for her, and I'll show you what I mean. Okay, so write this down. Put on the 22nd of October 2018, comma, Miss Felicia Jane attended Mr. Brandon Hughes' offices.
Sorry, could you repeat? I think I got confused at the beginning, sorry.
Felicia, you can repeat what you wrote.
On the 22nd of October 2018,
comma.
Yep, comma, Miss Felicia Jane attended Mr. Brandon Hughes' offices.
You got that, Brandon? Okay. And parties had entered into a share sale agreement whereby Miss Felicia's company would purchase 15,000 shares of Mr. Brandon's company. Full stop. Then the next sentence should be, Mr. Brandon Hugh had agreed to Miss Felicia Jane paying 4 installment payments for the purchase price. The payments were meant to have completed by 1st of December 2018. Full stop. Ms. Felicia Jane failed to meet those payments on time. Full stop. Mr. Brandon Hill is now seeking legal action against Ms. Felicia Jane. Full stop. However, comma, the agreement for the installment payment was not recorded in any document. Full stop. Mr. Brandon Hill now asserts or alleges that she was to pay the the full purchase amount on the 22nd of October 2018 itself. In the circumstances, comma, Mr. Brandon Hill alleges that Miss Felicia Jane has breached the share sale agreement on 22nd October 2018. The issue before the court is whether or not A, there was in fact an agreement for installment payment, semicolon. B, whether the breach had occurred on the 22nd of October 2018 or the 1st of December 2018. C, whether Mr. Brandon Hill, correct, is entitled to, I think I'll see, I think 2 issues is fine now. Okay, so you are now to put all of that facts I've just given you in the most simple manner, phrasing the issue. Now, if you don't send that, I'll see. So if you're already drafting your submissions, right, these are your background facts I've given you, right? So it be your background facts. Now you have to deal with the issue, right? Like, let's put an issue, whether or not, I think I've kind of already given it to you, and then you have to submit on it, like.
Okay.
Try doing, no issue. There's no that right, there's no wrong. That's why there are so many of us here that's trying to draft better every day. Okay, I'll give you some time to think. Maybe I can give you an example. I also won't put Brandon on the spot. So what I'm trying to say is this. So these are the facts, right? And it's already in your background facts. So when you submit on the issue of, let's say, the first one, of course, the dispute is whether or not one, in fact, he did agree, because I'm saying it's not documented anywhere. It's just maybe him saying, it's okay, like, you can pay me in 4 installments, chill, it's fine. As long as you pay me before the 1st of the December, it's all good. And then maybe parties have some disputes, as parties always will. If not, then there's no court and there's no litigation. Then he says, actually, no. The moment you sign, I expect payment. And perhaps some of you are thinking, oh, wouldn't it be stipulated in the agreement? In the ideal great world, agreements capture everything. But you'd be surprised when you start practice how people always forget to say what the terms are, or the terms don't necessarily reflect the agreement, or people will say, I agree for 4, then they can make it to 6, bring it down to 1. Because in the real world, people talk, they negotiate, then there's financial issues, people depart from terms. That's why they go to court, because if everyone had said something on the document and they followed it to a T, we wouldn't have a job, because there is no issue, right? Everyone lives in this great world where nobody argues. Okay, so what I'm trying to ask Felicia to do, if it didn't quite come across to all of you, was I've given you all a set of facts. What I'm asking you to do is formulate your issues. How would you start? So if I have to take a role. If I'm a role where I'm counsel for Felicia, I'm going to say that depending on when I'm giving you my argument, then I'm telling you how to say it, okay? If Brandon truly believed that payment was to be made on the 22nd of October, I would try and hit on the point that the time by which he started this dispute. If it's 6 months or 4 months or 10 months down the line, then if truly there was that agreement, why did it take him so long to initiate this action? By virtue of the fact that he taken so long to come after her, only gives us credence that there was no such agreement to pay immediately, but rather there was an installment payment. You know what I mean? That would be her first argument. The second argument would be, if I'm acting for Felicia, is whether or not I breached it then or now depends on whether there was an agreement for the installment payment. So if the answer is to issue A is affirmative, it would then flow logically that B would be in the negative. So how do I put this in words? I would then say, we submit, the first line would just be, we submit that there in fact existed an agreement for installment pay of X amount for these purchase of shares between the parties, full stop. That's the first, that's my premise. That's what I'm saying. Because my issue number one would have been whether or not there was an agreement for installment payments, correct? Then my first sentence would be, we submit there was, in the circumstance, or rather in support of this contention, semicolon dash one, we set out the facts. On this date, use dates on 22nd of October 2018. So and so, man, where? To purchase what? Full stop, short sentences. Okay. Thereafter, if you had made a first payment, state when. Then you hit what I'm trying to say. That if it's only happening, let's say in February next year, because I didn't give you the facts as to when you swing. So I'm trying to hit on that. If there was truly an agreement to have paid you there and then in October, wouldn't it make sense logically for a normal, reasonable person to have come for the balance payment immediately? And then I would also look at the point of transfer. If he truly believed that there was no time that would have had to lapse before the 4 payments were made, why would he then have transferred the shares? You know, then actually, if you want to think further, you can actually use issue transfer. But see, so again, heading, set out in simple sentences your argument, develop it. Then of course you submit on the law as well. Say in the case of what, high court case or whatever, or court of appeal case or whatever, this was the principles of law let down. I'm sure there's a multitude of cases out there where the conduct of a person, timing, you know, that you don't only need like documentary evidence, then, you know, if there's an oral contract, you know, submit on it, then the law comes in. So the facts, the law, remember I said, apply the law to your facts. Does that flow? Any questions so far? Am I losing anybody? Does anyone understand what I'm saying? Hi, good morning, everyone. Okay, so you get me? So try and say what you want to say in a short amount, the shortest sentence you can possibly think, without losing the meaning, of course. Don't have hanging sentences or things that are grammatically wrong. What I'm trying to say is, you don't have to say like, don't have to say, you get me, very long sentences, right? I mean, I can't top of my head think of a very long sentence, but I do tend to see people type again and there's a comma and there's like 10 commas in that sentence, when you can actually cut them down to like 3 or 4 sentences and a lot less words can be used. For example, recently I saw a draft by one of my colleagues and it says, by a notice of extension, this employment contract was extended for the next 2.5 years. But wouldn't logic have dictated that a notice of extension extends something? Then wouldn't it have just been that by virtue of notice of extension dated so and so, the contract was for, you know, the employee's employment was to terminate on whatever day. You know, you can say it. Because the outcome of what you're trying to say is that he no longer was just an employee for 2 years. It became like maybe 4 years. You can try to say? I hope you get what I'm trying to say. Like, there are unnecessary words. There are words there that don't play a role. And as you grow older, as you draft more, you need to cut your words down. Because some words are just fluff. They're just there because, I don't know, people have what we call verbal diarrhea. Like they just feel, or they just feel the word need to put a lot of words in a page, and there's some satisfaction maybe in typing a lot. I'm not sure. But you know, sometimes it only serves to complicate things. Okay, so then we go down to, if I can give a tip now since we're talking about drafting, a tip is when you cite cases, it would help if you cite the type of court. For example, in the case of the federal court case of Cubic Electronics, and then in the court of appeal case of maybe, you know, Bank Negara, or in the sessions court. So it tells the reader, either the judge or your opponent, the moment you're reading it, the level of authority you're citing. A lot of people tend to just whack in the name of the case and citation. And then the poor person has to go and look and see, hey, what is where, what court is where, you know. But when you, because when you have, and I think by now in law school, they would have already told you that you try and cite court of higher authorities, like federal court for appeal, and you go down high court. You know, you cannot possibly be going to the federal court or the court of appeal submissions by citing sessions court, because that's like a huge gap. I mean, unless you really can't find that point, then that's very different. Okay. So I've covered framework, I've covered headings, I've covered drafting. Like I said, Yvonne just remind me to show you all that sample that I promised to show you all. Okay. But one thing you must also remember why I'm saying don't use more words than necessarily and don't have long sentences is because, especially in the Court of Appeal, they actually have maximum number of pages for your written submissions before an executive summary is warranted. While the Court of Appeal won't stop you from sending, like I said, your 199 pages because you love your case so much, they then dictate that you need to come up with a summary. So whilst I would then say that you should come up with a summary, I would be very hard pressed to find a judge that would have been very impressed that if you could have said it in these amount of pages. I think it's 5 pages, if I'm not mistaken. Why you use the remaining 194 page for? You get what I'm trying to say? But like I said, there are exceptions. Nothing is just fixed rule. Like I said, very complex cases warrant that. Okay. So, Farah, can I just clarify? I'm allowed to speak to them about their submissions, right? This is not just litigation, right, Farah?
Yes.
Okay. So I'm just going to digress a little bit before I give you the remaining 4 or 5 tips I have, or guidance notes, if I call them. Is in arbitration, there are no fixed forms. Even more so, there are no fixed pages. And many a time for arbitration, there are very novel issues between parties, which are, of course, as you know, arbitration is confidential. So we do all sorts of things to assist the judge to help. For example, one of the matters I am sitting as counsel for is supply and delivery of pressure vessels. Pressure vessels are things above buildings. They actually are like tanks. And if you Google a pressure vessel, you probably find it. Okay. So when you come down to that in arbitration, I mean, most court cases are commercial, civil, I mean, they're construction issues, but it becomes a construction arbitration engineering aspect. So the argument could be in terms of the components, right? But if I ask any of you what a flange is, or what legs are, or what skirts are, I don't think you're thinking what I'm thinking. You're thinking legs are things on your body, skirts are things girls wear, correct? Actually not. Legs are the tool or the base by which a pressure vessel sits on. Skirt is what goes around it to give it more support. But if I'm going to explain that in my written submission, which I'm saying you can do it now in courts, they allow it at a large extent. And they also allow it in arbitrations, of course. But what I'm trying to get at is, my next tip is pictures, diagrams, photographs. They help, but of course get authoritative ones. For example, if I wanted to show you a diagram of what my client was meant to have delivered by way of pressure vessels, if I now told you they were supposed to supply and deliver pressure vessels with a skirt, what would you have thought? Like what a square thing with like a skirt like that. But and I would just describe it, is it? It is a metal component using what with a round thing flat by it. If you can imagine, great. But you and I would probably imagine the wrong thing, different thing, right? But if I just put on a diagram, this is what was supposed to be delivered, this was what was delivered. Don't you think immediately it gives the judge, oh, okay, I got it. If I want to tell you what a flange or a bolt is, I can't say what a pentagon thing with a hole in the middle where you screw it into. I just give you a diagram. So I'm trying to say one other tip would be, where able, put it into perspective. A picture or a photograph, like I said, reliable one, diagram, speaks 1,000 words. Then you cut down the need to explain. You cut down the need to have us think so much and imagine. Some of us have horrible imaginations, so I don't know where that will go. And it's easy, you know? The other thing is, since I'm on diagrams, right, I'm a huge fan of tables and schedules. Like if I wanted to show the judge that Felicia was meant to have paid Brandon these 4 sums on this day, the traditional way would be on this day, X pays Y, Z amount. This day is so boring. But if I could put it in a table, it would be date, amount, where, document. So it's there. You can see it. You know, it's so clear. You're like, oh yeah, okay, got it. Oh, when you were meant to pay, when you did pay, so that immediately just looking at it, you came into the numbers, it just jumps at you. As opposed to you reading 3 or 4 paragraphs of, oh, supposed to pay, didn't pay, or pay when. Then I go back, when was the first payment again? You know? So use these tools, diagrams, tables, schedules. They really greatly assist because, you know, and then I also like to use appendices. Like if I have tables that I want to assist the judge, but I don't want to put in the body of my written submission because it makes it unnecessarily long and it detracts from my argument, and people are just flipping back and forth saying, hey, where's the first issue, next issue? I just say the list of a table listing all these parts that were not delivered, or warranty list or whatever, or banking facilities, it affects all sorts of things. Please refer to Annexure A appended to this written submission. They immediately see, oh, if I want to see the dates or the schedule, I go, okay, got it, come back. Is it? So these are certain things that people don't teach you, but from experience, you eventually will learn. These are what I call tools to make effective written advocacy. Okay. And sometimes it also gives them a certain guidance of, you know how information is compiled, and then there is some order into that presentation as well. So far clear? Any questions so far? Okay, maybe right now I can just show you the example that I promised. So far now, I can share screen, is it far?
Yeah, you can share screen. You're the co-host already.
Okay, thanks. Just give me a minute to call it up for you guys. Okay, share screen. Can you see this? Can you see this? Is everyone this? Can someone tell me? Yes, Farah can see?
Yes, we can.
Okay,
Yes,
so
we
like, this is part of an arbitration. So what I was trying to say was basically this in a summary. We were arguing about whether there was an issue. Is this big enough, right? Should I zoom in? One try and see. Okay, it's not as clear here. Like, okay, for example, right? This was an analysis of the quantum that was claimed, guys. Like I was saying, skirt against leg, okay? Why there was a difference in price and how do we sort of explain that it was excessive and exorbitant. So we did up this table, which does deal with weight. And then we said that we did a mathematical computation of the difference in percentages. We explained what it was. We did price as well, so it's weight and price. And then we did the unit rates, and then we had argument here. See, all of this would have resulted in paragraphs and paragraphs of submissions that would have just been words. But once I put it in a snapshot of where necessarily, of course, it doesn't apply to everything, it enables the reader or the judge or the arbitrator to see how it actually is compiled into a table, okay, like a snapshot. Okay, and then for example, whenever I refer to very lengthy contractual provisions, I tend to type some of them short ones, but sometimes where I want to emphasize, so I've already said it here, that the data sheets actually state this, I say what it says, then I reproduce by way, I think you can excerpt this up from the actual document, put it in. So the person that that's actually reading it knows that you're not just saying it for sake. You're cutting short their work by saying, I'm saying clause 1.3 states this, but I'm showing you the actual cut and paste of 1.3. You know, the power of that. This, by looking at it, they're like, okay, so the person reading it, or the judge or the arbitrator, is not going to have to pick up bundle A that has your contract, flip to clause 1.3 and look. He may not, but it's there. You know, it's effective because written submissions no longer need to be just black and white. Where you can jazz it up to assist them, do so. Diagrams, tables, schedules, annexures. One thing I would also want to emphasize is chronology of events. If your case can be made better by telling the judge, this is what happened, this is the end. And if you are to do a chronology of events, just by virtue of the documents or the meetings and whatnot, you will see actually just by virtue of having a chronology of event, it tells that story for you. You can find out where the issues are. You can try and say. So when it's a bit of a hard work. So for example, if you did like a construction dispute, the problem would be, of course, people will say, oh, there's a delay here. They never informed us in time. They did not claim it in time, and so on and so forth. But in actual fact, if you set up a chronology events, you can do it in the body of your submissions if you have the space. But if you think that you unnecessarily lengthen your written submissions, put it as an extra, you know? So the person that's reading your written submissions will immediately know that, oh, these are the events that happened. Well, actually, this was the first time the issue of delay came up. This is the second time. Oh, this was what was done. There was no response. Then immediately it comes up to you. So you're actually organizing the documents you have to come up with a particular document, supporting document to assist. So far clear? Any questions? No, no one's gonna, no questions yet? Okay, so if this is how it is, so I'm going to suggest that Farah, then we have questions from 11:30 onwards then, since then people will have their questions already. Is that okay?
Yeah, it's okay. Sure.
So,
Sorry to interrupt, Miss Anita. So, like, because we have distributed the moot problem for like the participants, so maybe during the half an hour session, you can also ask like if, especially for those participants who have prepared for the moot problem, perhaps they can like show it to you, and maybe you can give them like comments or feedback like that.
okay, can. I mean, that would be great. Yes, I'm happy to. Okay, maybe that we can do that at 11:30. Yvonne?
Yes.
Okay. The other thing I would say is, and I think maybe this is something I should say in the outset, but I think it's fine to say it now too. There's no way even a great advocate is able to draft something overnight. Like you cannot just produce written submissions like that. You know, first is of course knowing the issues, like I said, having the framework, doing the research, which I'm sure all of you can do, and finding authorities that are, you know, supportive of your arguments, which are of superior quality. If you can't find it in Malaysia, go to UK, Singapore, Hong Kong, find those the appellate courts, the more convincing ones. So if you already have your legal research completed, when you're drafting, you can just draft. And I always think that you need some time to draft. I mean, okay, of course, in the ideal world, you get weeks for it. Sometimes I know you don't. But if you have that luxury of time, draft first, like draft out a first draft, and then go off to bed. So this is a tip, like it's not really like you have to do it, but I find it helps. Go off, sleep, rest, and then come back. And when you look at it with fresh eyes, you'll find that certain things you pick up on some grammatical errors, or you have some fresh thoughts, or you're looking at it, you're like, oh, why did I say that? Does it make sense? Give yourself time to edit. That's what I'm trying to say. And that in itself, you will find that you cut off unnecessary words. You will cut off things that are not relevant to your case. You get me? So it will assist greatly in the end product. And nothing rushed will be great. Nothing great should be rushed, if that makes sense to you. Actually, you know what? Does anyone want to show me the participants, like what Yvonne said? Anyone wants to show me their submissions, or anyone has questions with what they submitted? Then I can give a feedback here now. So then we can look at my submissions after that to see what I should show you all. Anybody?
Hello, Miss Anita.
Hi, Daniel, is it? Yes, hi, nice to meet you.
So I'm not showing my written submission or anything. I just want to ask a simple question. Like when we when we want to reproduce a very lengthy case, like the paragraph is very lengthy, but the point that we want to put forward is just a very tiny portion of that very lengthy paragraph. Can we use like ... and then like?
Yes, you can.
You get what I mean? Okay.
Yes, I'll show you a sample, 1 second. So the answer to your question is yes, you can. As long as you're not misrepresenting where the ... stops and ends. You get me? So let me give you a sample. Okay. Okay, let me see how I can make this bigger or smaller. Okay, wait. Can I share this statement from Zoom? Okay, Faraz, can you see this? Yvonne?
Yep, we can see it.
Okay, so what is this? This is this. Okay, so this is my corpus submissions. You can see I have an index. So this is basically this is a short submission because there's a page limit for the judgment, for the submission, sorry. So like I said just now, see introduction, salient background facts, links, and then so these are my issues, and I tell them which page to which page. So the judge wanting to read a part will go there. So I think to answer Daniel's question, I'll just go quickly to that. Is that okay? Like for example here, Daniel, are you with me? Daniel, are you with me?
Yes, I'm here, Miss Anita.
Okay. Let me try and give you a sample. Okay, yeah. So this was an extremely long paragraph, longer than this. But I only wanted this first line. Okay. So then when I'm done, I put ... Can you see that? Can you see that?
Yes, I can see.
Okay, yeah. Then I put, so for each of these paragraphs, I only wanted this line. So I stopped where I wanted, but I put that 3 dots. This tells the reader, the judge, or your opponent that actually you are only emphasizing this, which is smart because what you're saying is a very good tip, because you don't want to put 15 pages or 10 pages of just excerpts from the case, right? Of course, then the next question people will ask, why you highlight and underline, why do you highlight and underline certain portions? So these are the parts I want the courts to read, but these are the parts that I actually think the court needs to pay more attention to. Means I'm saying this is relevant to the issue I'm submitting here. Clear? And I'm emphasizing that there's also no counterclaim in this case, so it's same with mine and so on and so forth, you know? Okay, so like, see, when I said just now to cite in the Supreme Court case or whatever, you know, it tells the court it's a Supreme Court case, or see in the High Court case or whatever, you know. And then there's this thing that we do, most people do it, when you cite from a case and when these are not part of the original excerpt of the cases, you will put the emphasis added, telling the judge and your opponent or the reader that these were not part of the original case, but we would like to bring your attention to this parts of it. Then you use the words like emphasis added, our emphasis, means it's yours, you edited it, okay? For some cases, the judges do actually highlight and emphasize certain points. But when you are doing yourself, those parts, then at least just state there that it's your emphasis, okay? Any other questions from those involved with the moot? Anyone wants to show their submissions? No? Anybody? No? Okay. Okay, then I'm going to go back to my presentation then. All right, so we've spoken about framework, we've spoken about content, about how you should draft, what words you should use, don't use more than necessary. We've already said things like using tools to assist in your drafting. One last thing I also want to say before I move on to anything else is a counsel note. This may require a little bit more effort, but I think it helps in the sense that you prepare something even shorter, like maybe a couple of pages to guide you when you speak. Because whilst in the High Court, you may have some time before the judge, but let's say like in your moot, maybe then after that, Yvonne, I can give them some tips on the draft. But you see, they already submitted their submissions, right?
No. For the moot competition, right? They are not going to submit the written submission. It's just oral submission. But
All right.
they are going to learn about how to draft a written submission here.
Okay. Okay. So I find that it helps to do a 3-pager where you put like issue 1 and you really summarize what you want to say. Because sometimes in appellate courts, the judges don't give you time to take them. You won't be reading your submissions to them now. Let's be real. They can understand English, they read it. They just want to ask you, okay, point 1, what do you have to say? And you in that spur of the moment, if you have like, even like a 7-pager of summary, right? And if you don't have like a counsel note that guides you, you won't be able to say in a few sentences what your point is, you know? So I find that helps. It's extra work. Effective advocacy is not just preparation. That's very important. I think I can never overemphasize that. But sometimes you'll be caught off guard by judges because a lot of people have this mindset of, this is how I've drafted. Okay, I'm going to submit as I drafted. But that tells me you're a rigid advocate. You should be someone who can be able to think, if I said, okay, no, Hashmini, I would like you to submit on the point of this. And then you're going on the first point of whether there was a contract. No, it's fine. Okay, assuming I say that there's a contract, tell me where's the breach. And you're like, oh, but I've not gotten to the breach part. No, just submit. And you can't be telling the moot judge or the actual judge that I'm not there yet. You know, you can't quite say that. You have to say, okay, yes, the breach happened here. You know, but what would happen? You can't be, wait, sorry, let me go to my written subs. By then you've lost the judge, she's asked you to sit down, means you don't know your case. And it's not sometimes your case, because you may have a complicated matter where there may be multiple issues, and to you, in your mind, that flow helps. But in my mind, as a judge, I don't want it to know the whole story. I don't, what they always say, the grandmother story, I just want the answer to my question. Good judges, guys, would have all girls and guys would have already read your submissions, understood the issues, and formed their impression. So they just have questions. They're not here to listen to your very well drafted submissions. They just want to know the answers there is in their heads. And you must understand, you as an advocate would have prepared for that one case. I, as a judge, would have sat there reading tens and thousands of briefs for the past few months, and I've got no patience. And please, by now you must know not everyone has great advocacy skills. So some would have annoyed the judge, some would have impressed the judge. So patience level, expect it to be at the lowest. But I do give you some, well, consolation if that helps. They are patient judges, but they're few and far between. That's what I would say. Not in a way bad to anybody. It's just that you must put yourself in their shoes. They hear people coming in and out daily, one case after case after case. And they're just like, really, I don't want to hear so much. I just want you to answer. And the counsel note guides that. It tells you, okay, for this point, what's my strongest case? Because you know, sometimes you cite like what Daniel says, no, you cite a long case. And it just is actually which part you want me to see, you know, but when you cite, you just put like page, whatever. Oh, Daniel, then a good tip for you, if you're gonna shorten parts, right after that citation, put page what of that case, like page 365 lines G to H. So immediately you can go there, because the other part would be, I'll speak to you all about practical things about bundle authorities. You'd cite line and highlight and all that, right? So immediately draws the readers to that. Then if I am a judge and I'll see, hey, where did he excerpt this from? Paragraph 37. Okay, what is the page? If you could put page 369 lines G to H, I will immediately go there. Okay, thanks. So your written submissions must, at its best, be very comprehensive in terms of referencing, which was my next point. Referencing is key. Make sure you cite the cases properly, no errors in the names of the cases, the courts, the citation, the page numbers. I know you all said written advocacy, but in the real world, written submissions cannot exist without cases, and therefore it cannot exist without a bundle of authorities. So I'm going to spend like 5 minutes telling you about how it is. To those, I'm going to assume you all don't know, so I'm going to take you like kindergarten of bundle authorities. Bundle authorities are basically all the cases you cite or want to cite refer to either in or out of your written submissions, compiled into a bundle with an index, paginated. I like tabs and pagination. So I'll put a tab 1, that's my case, 2, 3, but I paginate each and every page of that because it assists greatly when you reference them to your written submissions. Good referencing, a good bundle of authorities go a long way. And if you all are going to be joining practice anytime soon, you by now realize that a lot of our hearings are virtual hearings. We've departed very much from physical courts. We still have them, but I think for a while now and for a long while more, appellate courts, court appeal court will be online hearing. So there is no greater emphasis on the need for a very good bundle of authorities because it's the PDF document that you file in and it's the PDF document that you eventually refer to. And I'm not going to be too technical about it because all you have and all the judges have before them is that electronic document, and you are sharing your screen. The need for that pagination and proper referencing helps greatly because you do not want your referencing to be wrong. And either you are assisting or you are counsel, and he's saying, okay, page 19 of the bundle. Because when you PDF a document, your page 1 on that PDF is actually the cover, right? Second is your index. Third is the actual case. So in actual case, if you start paginating your case at page 1, when I say page 1, it's not the one of the PDF, it's one of the actual document. You guys see what I'm trying to say? Am I clear? So those are things we now need to think about, or we've been thinking about for the last 1.5 years. So it all started in a very, I would say messy, yes, because first, I think not all lawyers are tech savvy. B, we didn't quite understand how all these things work. But see, once you get that down to a T, it assists. Same goes with your written submissions, whether you paginate from page 1 because of the PDF, which is what we do now. We just take it from the top 1. So then when you call it up, when you say page 3, it is the 3 of the document. You know, there's a 3 in the document, 3 in the PDF. No one gets confused. Okay? So I've done all that. My last one would be conclusion. Have a good conclusion, 1 or 2 paragraphs at the end to summarize everything, and then say what you have to say at the end. Like, we submit that this claim ought to be dismissed with cause, or for the reasons above, we submit this ought to be dismissed with cause. Always end and transition. Have transitions as well. Remember when I said just now, issue 1, issue 2, go flow. So it goes back to the first thing, framework. Your arguments must flow. How you draft tells the reader and the judge your mindset, your thought process. If your thought process is not clear, and it's not clear to you what you're trying to say, it's also not going to be clear what you're going to say orally. Of course, I would never underemphasize the need to be able to be flexible. Like I said, maybe certain issues are not part of the court's considerations. It's convinced. It may be the case is good for you. The judge may say, actually, I've got no issues with this issue. I agree with you, but I've got these issues. You know, then you must see, okay, how do I go with this? And this has probably very little to do with submissions, and I hope Yuan Farah doesn't mind if I just digress a bit of it. But always be prepared with answers, potential questions and answers. Be your own devil's advocate. And you can actually put it into your written submissions. Means, if I am supporting an application to strike out a claim, let's say I am, so I'm the defendant, and I think that this case has no basis, is frivolous, is vexatious, it's a waste of courts and abusive of process, I would know that that's what I would say, right? But what would my opponent say to defeat my striking out? That it's not there are issues to be tried, or there is a basis for it, it's not frivolous, there are these parties disputes. So I will actually put it. I will state in the outset of my summary why the striking out ought to be allowed for these reasons. And then I will say potential arguments or possible arguments by the other side. Or we will say that, oh, it may be submitted that these are, so you attack first, you preempt them. They will come back to you in your reply, but you already have the judges, you are saying, you don't only just have to do your submissions in a way that, oh, how can I win? But you also win not just by proving your case, you also win by defending the claim. Instead, defending what they say. Then say, this has no basis because of this reason. So you're shortcutting everything. But that's also a bit of a strategy, and you need some experience to know when to apply that and when to back off. Sometimes you don't have such a superior opponent. I mean no disrespect, and maybe therefore you don't have to go so harsh at the first round of your submissions, you get replies. Some judges will tell you, like in the court view, they don't actually want replies. So deal with it in your submissions and you take up orally. But like I said before, if it's not written, chances are it won't go into your record of appeal. Understand? Yeah, so you need to apply your mind. Something that I always say, apply your mind, think. You're not a robot. Don't, just because you've done a particular piece of work before a certain way, don't slavishly follow that precedent. Precedents are always guidance. Not two cases are to be argued the same way. Sometimes you win and lose a case based on facts, sometimes on the law, sometimes on the application, sometimes just because the documents are not good enough. You know, so think, apply your mind, think. You must always remember that whether written or oral advocacy, you are the advocate. Understand? Nothing beats research. I know not everyone in this room, myself included, are superior researchers. Not everyone. Some of you may be stellar. Sorry, I'm not. I always know your strengths, know your weaknesses, where you're not strong in a certain area, then make sure you spend more time in that area. Some people are better draftsmen. They seem to be able to string words just like that. Great for them. Some of us, not so good. Some of us are very good on our feet. So there are things like that. You need to know yourself and concede and work on your strengths, but also work more on your weaknesses so that you balance it up. Okay? So I think the last thing I will do is just to wrap up. I mean, I'll take questions after this, but just to wrap up to say that I think I should say this. Please ensure there's no grammatical errors. That really gets annoying, you know. Grammatical errors are not so bad. Typographical errors really make the reader upset. It means you know what the assumption is when you have a typographical errors, you didn't bother to read. Or either if you have, if you have a medical issue, that's fine. Let's it's like dyslexia, fine, that's fine. But there are things that it's like is was or MR, or there's a R in the middle of nowhere, or a full stop and a comma, and just like, you're just thinking to yourself, did this person draft this in his or her sleep? Because if just reading it again, you find that certain things should not be there. You get me? But there's this thing that a lot of lawyers, and I'm not saying I'm not one of them or I am one of them, unfortunately there are a group that just copy paste. When you copy paste and you don't read it through or proofread it, and like I said just now, fresh eyes, that's why it goes back to what I said, time to edit. You must give yourself time to edit. read through it again. And sometimes you have this eureka moments of, wow, so smart, I got it. But then you don't even know how you got there. But that's great. Then there are moments you're like, did I actually just type that sentence? It makes no sense to me now. You know, at least you can go back and amend it and fix it. You know, there'll be great moments, there'll be bad moments, but nothing beats reading it again. And I know there is this thing, it happens to me. After a while, when I read my first, second draft, it looks perfect to me. Then I print it out, I read, why like that? Why is there a T missing and a dot missing? You know, after a while, your eyes also starts to play games on you, and then everything looks perfect. So no, just print it out on draft paper, have a look at it. If you have a good friend, do you mind having a cast of fresh eyes and let me know, does it make sense to you, any typos or not? You know, because your first few piece of work for anybody you're working for, you must aim for perfection. The principle you must have is, are you proud of this piece of work? Have you done your best? Could it have been better? And nothing beats time, preparation, and hard work, unfortunately. Okay. And Yvonne, do I need to cover the point on research a bit? Would that assist?
I think you can if you want to,
Okay.
since it's related to written advocacy.
So okay, I'm not going to teach you how to research, okay? But I always believe that there is an overemphasis in today's younger lawyers or younger students on just online resources. I'm not against them. I think they're fast, they're great, they're good, they get you the jurisdictions. But unless there is any reason anyone is allergic to a library, please do go to a library, because there are textbooks, guidance books, secondary sources that can give you information for the subject matter faster than a case. I find that I won't call it disease lah. I find that the common practice is, I'll find a case that supports my case, done. I find another case that supports what I want to say, to stop. But if you're doing if you aim to grow and become better at what you do, if that truly is that passion, pick up a textbook. And by now, you should know, like, Sina Dura from Malaysia for contract. You know, if you're doing construction, there's heating, there's Hudson's, then there's Lim Chong Fong for that. And for a company, there is like Nishi, there's like Rosu Chiang, and those things, people books who give you the general principles. Read the general principle of that subject matter, whether it's aviation, construction, contract. Read it, get the basic principles down. They also will cite cases. Then move on to read the cases cited therein, and then look for cases that apply, and then go to the jurisdictions. Yes, I find that a lot of research I get comes from case first, and then when they cannot find the answer of cases, they go to the books. It should be the other way around. So if I ask, let me pick another person. Like, there's 4 pages here. Okay. Roshan. Is there a Roshan in this? He's muted and I cannot see his face.
Yes, there is.
Yes.
Can you turn on your camera? So can you?
Currently, I'm not in a situation to turn it on.
Okay, never mind. Hi, Roshan. Nice to meet you. Sorry, I don't mean to pick you. Just want to come from a different room. Okay. So can you briefly tell us how you? Okay, now maybe I don't put you on the spot. Do you look at textbooks when you start drafting a particular research point?
I
no,
do.
Honestly, just be honest. Okay. You do.
Yeah,
great,
sometimes
great.
I do. I try to.
And then,
yeah, but if not, I would usually look more at journal articles, to be honest.
That's good too. That's good too.
Yeah. I look at journal articles, blog spots. I try to look at textbook, but it's a bit, I think, because there are too much words going on, so I try not to go for it.
Okay, try to overcome that, Roshan. Because, okay, let's say, I mean, as you do more and more complicated, like a mood problem like that, like as they get on to be more and more complicated, right? You only serve to actually read, I mean, there are a number of textbooks out there, good ones and not so good ones. But if you can endure just reading a textbook on, let's say, the issue of design liability for, let's say, construction, right? It will assist if you just pick that book and read. So there's a basic understanding of it. Then you couple it with, okay, the articles are a great thing. Blog spots, I'm a little slower to go there because it depends on whose blog, if that makes sense to you. Who's the writer, whether that person has in-depth knowledge of that law, you know, like I know there's certain law firms and certain, I mean, particularly I myself also write for my firm. Some law firms and some very reputable practitioners, I would definitely go there because I do find that it helps. I think what you're trying to say is it sort of compiles and gives you a comprehensive look, like a starter, right? Then you go to cases. That's what you're saying, and that's a good thing. But if where possible, I would like each of you to try and go back to the library as much. I know it sounds very boring, and I know we are not a generation that necessarily believes in looking at lines and lines and lines. And it may sound a bit hypocritical of me because I just said, look, putting diagrams and schedules and stuff, but to understand the subject matter, if it's new and foreign to you, there is to me, no better way than to just go back to basics. Because I remember looking for a particular point for a company matter, and I could not, and this was just a year ago, I could not look for it in any case in jurisdiction. I found it in one of the oldest 1997 textbook in the library in my firm. And I was like, oh God, thank you for saving my life, because I needed that point for God. But I'm just saying, that's an underemphasis of using textbooks. You know, try sometimes. It may just be good. It may give you an idea, it may spark. But also be very careful. Don't go back to the old ones unless, you know, assistantly necessary to try to do the new editions. And since I'm on the point of research, I'll give you a few more tips. If you are going to look at statutes like Contracts Act, Companies Act, Employment Act, Evidence Act, in libraries, there's this thing called the Annotated Statutes of Malaysia, the ASM. Some of you may have come across it, some of you may have not. So they give a commentary on each section. They also highlight and explain those sections in the statutes, and they give cases. That would be a good point to start. If you're looking at a particular area of law, Roshan, if you think textbooks are a bit heavy, do look at Halsbury's. There's Halsbury's Laws of Malaysia, Halsbury's UK. They also give a snapshot. You know, Roshan, I would suggest you also try and look at those. They do deal with topic by topic.
All right, I'll check it out. Thank you, Miss.
Yeah, okay. So that's Halsbury, there's ASM. Also, there's this thing called Malal's Digest, everyone. Malal's Digest, I think, is a compendium of all Malaysian, Singapore, and Australian cases, if I'm not mistaken. So again, that helps because it's Australian, Hong Kong. But I know it's Malaysian, Singapore, and one more jurisdictions, right? I think it's either Hong Kong or Australia. So that helps because it, per the issues like shareholders' remedies or shareholders' oppressions, it actually has like a write-up of this is the case, this is the issue, and then it has a help on there. So it helps you navigate. It's not supposed to be a copy-paste. It's supposed to be this compendium that tells you if you're looking at shareholders' oppression or a particular issue, there's this particular set of pages that deals with these cases. So you see, in this case, helps. I will now go and look for the exact case of Owen Sim on shareholders' oppression, minority oppression. Okay, we'll take it. I'm going to Google it. So I'm going to search it on Lexis, download it, and read it out. So it helps your research. So there are all these tools out there that help make research a better process. I'm not saying all your ways are wrong. Like I said, some of you here may be top researchers, but these are just from experience. When you are rushing, like I said, in an ideal world, you would have a lot of time to draft your submissions, but also be prepared that there are times that you don't have that luxury. And therefore, these are things you can look at to just as a starting point. Okay. But of course, again, I will never stop repeating it. Apply your mind. Sometimes question. The best advocates are there that question. Cross-examine yourself. Cross-examine the case. Is it applicable? What can be challenged? What can I say? If I cite this part, oh, and Daniel, very important, be truthful. That's what I meant by ... Say what the ... is it, and you know, the one thing you don't want is to mislead the court and the reader and the judge, because that goes to credibility and the weightage of your written work. Okay? If that case says this part, so I don't know if you've heard stories where this part of the case is very good. Okay, sure, give me a minute, I'll come back to you. If you see this part of your case is good, Danielle, suddenly this part actually contradicts that part. Be honest to then say that whilst this was stated, or find a better case, be truthful, because many times I get given authorities by my opponent and I'm reading, I'm like, hey, this is distinguishable for these reasons, or this is not an accurate depiction of the case. Therefore, where you stop, how even if you want to just cite that portion, you just 2 lines below it say something different, you cannot stop the ... there. Then you're misrepresenting, be careful. That's why I think sometimes people are a bit more slower to ... I am a fan of it, as long as you are correct in representing what is excerpted out. Okay, fair, clear? Okay, Chi Yong had a question. Wait, let me see what he said. Made a deal. Yes, Malaysian lawyer, yes. Who is Yap Wen Han? Can I see and hear? Oh, okay, hi, yes. Okay,
Hi.
yes, I used to work with She in Skrine. Actually, she was my partner, my boss. He does write very good articles, but he's also a very good person in company law and insolvency. So that's a good site to go to. Yes. 2 sites. Do you mean the Halsbury's? Is that what you're saying? Chi Yong, who's Chi Yong? Oh, yes, no, they're not sites. Halsbury's, depending on your subscription package to your LexisNexis or your CLJ, you may have access to Halsbury's online, but the Halsbury's I am accustomed to, okay, my office has subscription to online Halsbury's, but I generally go to the library and take the physical copies of the Halsbury's. It's Halsbury's Laws of Malaysia, so they're books, and they go by type topics like employment contract, or companies or tenancy and whatnot. But there is a UK version as well, Halsbury's Laws of UK. And those would just be the similar things we have here, but English positions. Because as you know, it's persuasive and we do go back to them where we don't have that. Okay, so any other questions at this juncture? If not, I want to move to my last 2 points. Wong Ying, yes, I saw you turn on your camera. Any questions?
Actually, Miss Anita, I have one.
Who is, oh, hi Wen Han, yes.
Okay, no, actually regard to the one you said, how you do research, actually I have like a particular way of doing my research. For example, like you say, you prefer books to cases, right? I prefer the other way around, because that's where I start, like, let's say I'm doing my criminal procedure, I look for cases within cases, what the law, what the judges have cited, cases within cases. So it's like, it's more faster than books, because yeah, that's what I feel. Yeah.
Okay.
Yeah, like how the cases, like Supreme Court, they cite the cases down, and then I search and see, yeah, something like that. Then books is the only, I only resort to books if, let's say, I can't find the thing I want. Yeah. But cases is the first thing, yeah, on Nexus or CRG.
Do you want me to comment on that process, or you just telling me?
I mean, like, comment process, because like you say, books to cases, but then yeah.
When you say criminal procedure, okay, so I don't do criminal work. I probably have never had to do a criminal research except in bar school, but that's a completely different story, right? Because that's the white book, and that's also there's the, God, how long have I been out of bar school? There is this particular blue book we use. I'm sure I don't know what it's called anymore. But so what I'm trying, so Wen Han, that's fine too if it works for you. But why I don't always go to cases first is, after a good amount of years doing this, I realized that not all judgments are accurate. Not all of them do that research in the way that you say it to be. Several judges in Malaysia do that, which are it's very commendable. Justice Nalini, who's on the federal court. When I started practice, she was in the High Court. Justice Nanda Balan, Justice Nazlan. So there are some of the Justice Azizul. So there are some of them who actually take the pain to do even more research on top of the research that we do to do certain things, to pad up and give you that, if you are Justice Wong Keng Keong, things like that, they actually research. Justice Mary Lim, they actually research and add on. So even so they say the law of shareholders oppression, they actually set up Ibrahimi, and you're reading it. So that gives you. But if you ask me how many of the judgments out there are like that, few and far between, because it actually takes time to do that sort of type of judgment. You can still do that, but I think if you have a chance, all of you, if you're keen, pick up a Halsbury that I'm talking about. Halsbury basically is, if you're looking at, unfortunately I should have brought back a copy to show you, I forgot about that. If you actually pick up a book, a Halsbury, let's say contract, right? Within it, it actually has that interpretation of terms of contract, it's subheadings. And if you go to that particular part of that book, so it's cited like 220.09, that page, and you go there, it actually tells you the principles. And it has cases there at one hand. So right after that principle, let's say they will say interpretation of a contract has to be context or text or whatever, then they cite a case for it. Or maybe it's like ICS or something, it cites it, footnotes it, then you have a case. So for every legal proposition stated in Halsbury, it's cited down there. You get what I'm trying to say? Like, for example, when you start practice, if you do civil practice like I do, there is a Malaysian white book. Here's where I disclose. I'm not promoting it. I am one of the contributing editors, but I find it to be good because when I started being part of it in 2013, 15, 18, and 2021, I noticed that there is a constant update. So what it means is for the rules of court, if some of you have not seen it, is basically the rules of court that we rely for court work, like summary judgments, order 24, things like that. This is an annotated version of it. So you go to that particular order, you look at the particular rules, or order and rules you're looking at. There is a commentary by the editors there on the cases, and it's up to date. So the one that just got launched is 2021. So it's up until February 2021, if I'm not mistaken, the update of the laws in Malaysia, the cases in Malaysia, all relevant. Sometimes they put in Singapore cases, in UK cases. It helps guide you to explain the orders. You get what I mean? Means if you're relying on order 24.1, there is an explanation of that with cases that support that. You can go there. So this would be the reverse engineered way of doing this, but I don't know if it particularly applies to criminal procedure. I'm not sure, but that would be how I have been doing my civil practice. I hope that helps. Continue with what you're doing, but I'm saying maybe it will also be a bit more robust if you just try and pick up Halsbury and see how you would like to understand it first. Because then if it's an updated, I mean, Halsbury's get updated quite often as well. So with the white book and the Halsbury, those are the updated cases. So because I mean, you're one person and there's like a multitude of cases out there, right? And I'm not saying your research is bad or not good, but it just cuts to the chase and gives you a background, and then minimizes the risk of not having looked at all the cases that is relevant to your point, if that helps. Okay. Okay, so my library, oh yes, Tian Xin. Who's Tian Xin? Hi, Tian Xin. Oh, hi. Okay, yes. It would be Skrine's library. And unfortunately, I cannot take you in there. But I do understand that the UM library is very superior as well. So if you're able to attend to the UM library, they also have a very comprehensive, and I think they are open to public. I think you just have to apply or something like that. So yes, I use Skrine's library. But I think if some of you are from UK, I think your university subscriptions to the online Westlaw also is quite impressive. They have books and stuff, right? I'm correct on that, right? Because remember my interns having access to Westlaw, and they have access to books that are very good. Okay. Oh, that's good. That's good. One hand, that's very good. Navita, I agree with you, Matt. Okay. Okay, very good. Who's Navita? Hi, Navita. Navita?
Hello. Good morning.
Yeah, sure. Why can't I see her?
Oh, hold on. Hi. Can you see me now?
Oh, yes, hi.
Hello.
Yes, hi, nice to meet you. Okay, great. Yes, I mean, continue doing that. I'm not saying that you can't go to case law. I know they are faster. I'm just giving you from practical experience what can be used, you know, everyone. Okay. Any other questions on research? Okay. So if anybody has, they can just ask later. Precision of language. That would be my second last point. Don't use terribly colloquial English. I'm not asking you to use Queen's English. I'm not asking you to use bombastic language. I'm asking you to use to improve language every day. and we're able to say certain things with better choice of words, use that. If, like, you know, an example, when a lot of people, I think, draft as they think, as they would speak, when actually spoken English and written English is actually not entirely always the same, you know. Let's say a very classic example is when someone asks you, are you free at 5? And sometimes the answer you get, no, I'm not busy. So are you free? You know, it's like, if you can say it, but people try to use the convoluted way, I don't understand, you know, or can you do something for me? Sure, will be the answer. So when we say, I can, but why? You know, things like, I mean, conversational English is very different from written advocacy. And I think the emphasis has to be the word advocacy. Advocacy is a tool that you must convince. So your written work, when it's very impressive and it's drafted, well researched, well articulated, not confusing, shows your train of thought, will be one of the best pieces of work that you can read. Really, it can. One last tip I'd give you for now is, in very complex arbitration work I do, because arbitrators are not always judges. Sometimes they're engineers, sometimes they're architects, so the diagrams help. But because arbitration is very voluminous, at any given time, I think I cannot imagine to have less than 30 bundles of documents, just bundles. And to expect someone who is doing international arbitration to travel with 30 bundles, arguably maybe you can, but that's why the arbitration bundles for arbitrators tend to be a bit smaller. A3, you know, A5 size, the small ones. Mine is normally B5. So when I travel, it doesn't take up my entire luggage, because A4 is very, very big. I tend to do double-sided B5, so it becomes like about like the A5 is this size, right? So mine is slightly bigger, like maybe like that, like this. So it helps me. I can read, and I am aging, so I will lose my eyesight if I don't read A5. But then after that, what then happens is I embed documents. Means I use technology to assist me, because if I'm sending the document by PDF to the arbitrator as counsel, if I embed the document in, so it becomes an icon or a link to my submission, I click it, the document comes up. For example, if I'm referring to Section 3 of the Companies Act, I actually have Section 3 attached to it, either by way of having already scanned it, put it into a thing, and I hyperlink it or embed it into the document. So at any time, all the arbitrator needs is just to carry this soft PDF version of my submission, and he just has to click the bundle of documents, and he gets it. So he doesn't have to carry that 30 bundle and travel. So these are, so in doing work, so this doesn't quite normally always apply to courts. I don't think they are quite receptive to that yet, but it happens in arbitration. And I find these are, what I'm trying to say, there are many tools out there, technological tools, and you guys are younger generations, where you can use technology to make things work for you better. Do it. Think outside the box. Your job there is to facilitate, to guide and assist the decision maker to prove your client's case and hopefully win it. And there are so many things you can use to get that across. You know, make that person. So the moment the arbitrator or the judge feels that you are assisting, like I said, the tools like diagrams, schedules, hyperlinking documents, referencing, good referencing, you know, it makes the enjoyable process. And always know your submissions. If you are solicitor and then counsel arguing, when you've gone through this long and arduous process of preparing a very good written piece of work, when you stand up and you argue, it will come very naturally to you what you say, what you refer to, you know. May I ask if it's always okay to cite, please? Okay, Tianxin. Okay, hi Tianxin again. Yes, you can cite jurisdiction. Sorry, okay. Be careful about what jurisdiction you cite. Always try it. We would, for me, it would be best to try and look for appellate cases in Malaysia first, if it's a Malaysian case. Of course, arbitration is international, then whatever the laws of that seat or the arbitration is comes first, and then persuasively the other jurisdictions. Arbitration is a different feature in that sense. But if you're talking specifically for court cases, then Malaysia will be the first port of call. Singapore would be the other, the next. Then UK would be very persuasive. We go to Hong Kong. In years, I've seen people use Australia and New Zealand. They seem to have quite good cases there as well. But be very careful when you cite cases out of jurisdiction. My first word of caution would be, if it's a particular statute, for example, Companies Act, each jurisdiction by now would have developed and amended their statutes accordingly. Certain provisions in ours don't exist in theirs, certain provisions in theirs don't exist in ours. I find that between Malaysia and Singapore, more often than not, they are pretty much similar, almost paramaterial, almost. But you have to be very careful. Get the latest version in for the Malaysian statute, compare it to the whichever jurisdiction you're looking for, Tianxin, then see what sections, then look at their commentary if it's available, and if it's the same, then you can argue it. Because the point of having external jurisdiction is to ensure that it's persuasive. It's supposed to assist to persuade. You get me? So that would be my first precautionary note, to make sure that you are not just taking the case because it says what you want it to say, but the moment you do use it and you cite it, the other party will probably say, look, it does not actually apply because the provisions are different. One is mandatory, one is not. Therefore, I distinguish this case in this way, this way, this way, you know? Because if you know that there is that difference in the outset, you can say, whilst we accept that, you can cite it in your submissions and then put a precautionary line there to say, whilst we note that, that there is this difference in this way, we submit that it is still persuasive for these reasons. So you already preempt it that way, you know? Any other questions?
I have a question, Miss. Actually, I have two questions. Yeah, I have two questions. Okay, first of all, is about the diagrams and so on, right? Is it only applicable in arbitration cases, or is it applicable even in like high court cases and federal court cases as well?
Sorry, yeah? I didn't
Like
hear
the usage of diagrams, is it like applicable to like only arbitration only, or is it applicable to high courts as well? Like, can you use diagrams to explain in like court of appeal and so on?
Tables and schedules, for sure they're allowed because they're just compilation of data. More importantly is you must make sure the data that you're compiling and scheduling up are actually in the affidavits before the courts. Because otherwise then you're trying to put in more facts that are not before the courts. That's the difference with arbitration and court. You get me? So let's say you were trying to compile a list of warranty lists, right? That those information must be deposed by an affidavit. And stop me if you don't understand what I'm trying to say. Because in courts, if it's not trial by documents, which should also be in the bundles, your affidavits are affirmations of facts deposed by a deponent that says this like, okay, if just now if we use Felicia Jane's sample, she would have deposed these are the dates, and you're just compiling the dates, you know, or showing some documents. If you're talking specifically for diagrams in courts, I think as long as it's been shown and it's not disputed, but there's no issue, no hard and fast rule not to use it. But of course, if you say Court of Appeal Federal Court, they'll probably be like, could you have put this in an affidavit? I would not have thought so. But if you assist in making things easier, for example, I have put in an affidavit a relationship chart when I was trying to do a share transfer family estate dispute. You know, Elisa. So what I was trying to do is I was trying to show how this deceased had like how many wives, how many children, father, mother. So that became part of the affidavit. So that's a diagram as well. It's more of like a relationship chart that I created a chart. So it has colors and all that. That eventually made it into the submissions. Because that, like I said, that one snapshot of a diagram does not does a better job actually than me saying so and so's father is this, so and so had 3 wives, each wife had 5 sons. but that one relationship chart with that person going up, wife 1, 2, 3, children 1, 2, 3, father, mother, it just says the whole thing. And of course, clear description of mother's mother. There will be some limitations in court proceedings, I won't lie, because these help. But if you're saying like just now specifically whacking one bolt out there, I would, like I say again, assume that you would already be able to do in your affidavit, not in the body, but maybe you can say, now produced and shown to me and exhibited as AX1 is a picture of this bolt. Then in your submissions, you can use that picture in your submissions. You must understand the difference with court and arbitration is that court, if in applications, are based on affidavit evidence and trials and documents. So it must be before the court before we can submit on it. That's why there's a need. People always say you must plead facts or you must depose facts, then you submit. If not, they call it. And if you only do it in your submissions or orally or written, it becomes submissions from the bar. There is no basis, where's your factual basis. Whereas in arbitration, we would have raised it in our witness statement anyway. So then it would just be a submission. I hope that explains it. But yeah.
Yes. For my second question is, do you usually put inside your written submission as well for the, like, for example, you said books, right? Do you usually cite books inside your written submission?
I do. So I will say, like, if I do company work, because I do a good amount of shareholders dispute as well, I tend to refer to Siu Chiang and some of the Indian Company Act books as well. So if I find that those books assist or Pollock or whatever, then I will say in the whatever book by whoever, the relevant citation is how you cite the book. It was noted that the concept of nominee director is this, semicolon dash, I cite it. It gives that background of an explanation of what a nominee director is. A nominee director would be, of course, a director appointed by a shareholder to play its role for the board of another company. Look at it. And then I cite a case to it. Because
I actually have another one. Like, how do you judge if that book is a good book to cite?
Okay, as you grow along, you will find that in every area of law, there are books that are highly recommended. Like I said just now, contract, you have Sinadurai. Construction, you have Chong Fong. Company of Siu Chiang. I'm not saying the others are bad. Construction, you have Hudson's and Keatings and whatnot. Ivans for adjudication. There are no, I'm not saying that all books are good or all books are bad. I suppose if it's a book, no one's going to say, oh, it's a horrible book. It's just that if, as the person using that book, you just have to do the due diligence of looking at what it's saying, the cases it's citing, and whether the propositions and principles in the book is actually supported by cases or not. Understand? You cannot just be a line from book just because it says what you want it to say. It's a great book. But if it's in tandem with the cases you're trying to cite and the manner which you think you can defend it, that's a good book. So unfortunately, I can't give you a list of books to use for which area, but then I'm also not being honest in the sense that I've not read every book in this world. I for one will never say I've done that, because you know how the Indian books are very leading in terms of evidence. You know, that's the thing, hopefully if any of you do go to privilege or eventually start practice, you will find that your pupil master, hopefully, or the seniors or the lawyers you work for would have guided you down the line of what books to look at and what not. But of course, if you ever meet any of us in court, out, or at an event or seminars, you can always just strike up a conversation with us and ask. And I'm sure any given senior practitioner or practitioner would be happy to just share, oh, I think you should look at this book for these areas, Any other questions?
Hi, good morning, Miss Anita. I'm Jungsin.
Hi. Morning.
Morning. May I know how do we structure our written submissions in a way that it allows our oral submissions to provide arguments from different angles? Because normally what we state in our written submissions, right, we will have to state it in our oral submissions, but it kind of feels like it's a replication of our written submission. And it's also highly anticipated by our opponents, if you know what I mean.
So you're saying that because what you say when you stand up is the same thing you're saying written down,
Yes. Yeah, because I have, oh, sorry.
So there's no element of surprise. Is that what you're saying? The issue you have is?
Yeah, that's what I mean.
Sorry, okay, wait. What I understand you to say is that, for example, if you have a point you're making and it's there and you're repeating it, you want to try and be more persuasive, is it?
Yeah, like how can we make it a little bit more different in our oral submission?
But this would be oral advocacy, correct? Not.
Yeah, but how do we structure our written submission so that we can prepare our oral submission to be different?
I don't think you necessarily can do that, but I would assume that, see, unless you're reading your written submission, I would find it a bit difficult for it to be a repetition. Of course, the points you're making will be the same, but how you deliver it orally will be different. You get what I'm trying to say? You won't read the entire paragraph of your written submissions on the case from line to line. You'd probably just say, this is my proposition. And it's supported by this federal court case of this. But if you want to structure it, if you're saying purely on drafting, so that's what when you're saying it, right, already, you reverse that. If you are doing in terms of drafting, then the point would be to ensure that you state your proposition at the outset, okay? Say what you have to say, and then put up the law, put up the facts, submit on it. And in that course of how you draft it, so unless I'm actually showing you how to draft it, I think it'll be quite difficult on a session like this. Try and, like I said just now, anticipate what would be argued back to you. You can pick if you want to put it there, a signpost, but then your concern is the other side will know that's what you're going to argue and come back with an answer. And then in oral submissions, then address it. I don't necessarily think there is a way that your written submissions can necessarily depart too far in terms of content from your oral advocacy. Yeah, but I think that the idea of a written submission is not so much to attack or whatever. You can preempt, you can put it in there, but maybe you don't have to elaborate too much on it. You get what I mean? And then you elaborate on it when you stand up. Does that make sense? So you can sort of say, okay, the respondent contends this issue, this is denied, we will submit on this issue in counsel, or so and so will submit further on this issue at the hearing, because you can still have bundle authorities, further bundle authorities, and then you can elaborate that if you want. What you can then do, I don't think there's a need to hide behind and be too concerned about surprising or not surprising, because sometimes when they don't want to submit all the cases, they just put C bullet points 1, 2, 3, or rather not put that line, have a like a signpost, and then have those extra bundles in your bundle authorities, because if it's not there, you can't rely on it, and then you can submit it. So at least it's there. But the only point would then be in your written submissions, those points are not elaborated, but there's a line on that, if that makes sense to you. That would be my tip to have like the bundle. Sometimes I'll say this is a proposition of law. These cases are in support. I'll put bullet point 4 cases. But of course, by putting it there, they know. But then they know, but they don't necessarily know where I'm coming from. Then we will then that comes back to your oral advocacy. How you want to then explain to the judge why these cases support this contention, which does not support theirs. That's one way about it. That's how I can think about it. Okay.
Yes, thank you. Actually, I have one more question.
Yes, please.
We're supposed to provide 2 sides of the story, right?
Yes.
Not just in the favor of our clients, but how do we actually structure it so that it's not like very damaging in our position, but it's just like in a neutral position?
You're talking about facts or submissions, points, issues?
the issues and also the law. Let's say if it's damaging in our position, how do we structure it so that it's somewhat neutral?
I don't. So you're saying that there is a position of law that cases for and against you, is it? Is that what you're saying?
That's what I mean.
Okay, so I think that's a good point, good question. How I would deal with it if I was that would be, I think it's very important, like something I mentioned to Danielle, it's just to make sure that whatever you're drafting is transparent and honest, a true depiction of the stated state of the law. So you can say that, for example, you will find that as you go along, sometimes there's certain issues where federal courts have conflicting decisions. You just have to state why one decision is better than the other, or more in favor or whatnot. And that requires actually an understanding of both cases, or whatever those cases are that you say is not for you. Of course, the ones that are for you, you will rely on it. And then you will look at the ones that are not and say how they don't apply to you. So you have to distinguish it yourself. And I would find it better that you're upfront about it in your submissions than for it to be taken in reply. For example, to say that we do note that there are these line of cases that say these conflicting, however, they do not apply because for this case, distinguishable because it revolves around land and not contract. So the principles there are different, or factually it's distinguishable because there was no issue of proprietary interest or equitable rights, distinguish those. Like that is also, if it answers your first question, how do you preempt? So if you know that there is a line of authorities that don't favor the position you're trying to take, then address them up front. Deal with it. Deal with the elephant in the room outset if you think it's damaging to your case. If it's just merely another, you're in a high court matter, but it's a sessions court case, and you don't think it's going to terribly, horribly bite your case until they raise it up, then you don't also have to show your cards and say, oh, actually, there are these cases that don't help me. You don't have to, because it's not persuasive in the sense that it's a lower court. But of course, if it's a same level of court or higher, then I would advise in the spirit of being honest and transparent as one should be, you should highlight it, because they will then run the risk of your opponent saying in his reply submissions, by the way, the claimant conveniently or for reasons best known to themselves did not highlight to the court or bring to this court's attention the case of so and so and so, which goes against the proposition that they are actually following. There must always be two ways of saying something, otherwise nobody will win, right? Obviously, two people in that room, you and opposing counsel, take different positions. But as long as you are honest, transparent, you can't always expect that from your opponent, but you can expect that from yourself, because a good long practice has to be a good and honest practice. It has to be. And impressions with judges, mediators, adjudicators, and arbitrators, they stay, they stay, and they stay for a long time. Okay. Any last questions? Okay, so I think my last point, which I kept to the end, and it's really, it may seem like a trivial point, and all of you be like, really? Please have page numbers. I kid you not, the amount of work I see with no page numbers. And I am there counting the pages for my colleagues or writing it down myself, because I've and paragraph numbers. I cannot then emphasize on formatting. Please use fonts that are legible, good size, spacing, center, justify your documents, check and edit paragraph numbers, page headings, check if you're going to use an index which helps to navigate. Please check after you're done that there are no runnings of pages, that they do complement. And please also always check spelling, grammatical errors, full stop, typos, have spacing. You know, like how sometimes people's paragraphs, like, I don't know why suddenly they are like that, and they don't check. Read it again, PDF it, go through it again, Put yourself in the position of the reader, that it does not seem as though it's something you did with your eyes closed. Okay? That there is form, there is substance. Substance is paramount. perform a substance. Like, remember your written advocacy. Before I go, this is my last advice. Written advocacy is just what you want to say as counsel, put into words before the judge sees you. Your delivery, if your written submission is good, I don't expect everyone to have stellar. I do eventually hope all of you are stellar draftsmen, of course, but not everyone starts out amazing. Then at least do a good job. Then your oral advocacy can take it to another level. But if you imagine that your written submission is so bad that I'm just like, I can't even read it. No matter how good you are, when I see you, I'm like, how did this person draft this and sound like this? You know, it must come across like that. And the other disadvantage, if you don't do a good piece of written submission or written work, is that the amount of oral advocacy you have to do to play catch up. Oh no, I didn't mean it this, I meant it this way. I did not meant it this way, I meant it this way. You know, yeah, so yes, correct. Yeah. So it's very, and if you give me slipshod work of no page numbers, I'm like, this person couldn't even be bothered to check for typos and page numbers and paragraph and referencing. Why am I wasting my time reading it if you can't be bothered to spend your time doing a good piece of work? You know what I mean? Form over substance is something I emphasize a lot to people I work with and for or together, because I feel that it's like human interaction. You and I can have a conversation. I can start shouting the same contents to you and you would have blocked me off. Although everything I say makes sense. But if I actually take my time, sit down and explain to you the same content, you will take it. So it's form, not substance. It's how people argue, because they start shouting, they start raising their voices, they cannot seem to reel it back, calm down, and say it nicely. It's the same thing. Your written submissions is there. So no need to use emotive language. I mean, yes, we do try and swipe each other a bit here and there, because they always say, leave your affidavits and your written statements emotionless, because it's just statement of fact. Submissions is where you can have some emotions. You know, that's why words like, it does not lie in the mouth of my opponent to now assert, you know, those words comes out. That's just flowery language. It's just written. As you go along, you know, people use idioms, and that's just drafting. There's a complete different style. And then I think drafting is, I mean, if I go down to drafting, it'd be a drafting class really. It's a different thing, you know. But that in itself shows flair and command of the language. And always read a lot. Go and read a lot of written submissions, read a lot of work from good people like Tommy Thomas or Gopal Srinivasan and whatnot. So they do write very, very well. They draft very, very well. And it helps because you see how legal drafting is done and how they present their written submissions and how they present their cases, you know, the thought process, their arguments, that really helps. I have a particular partner who he's a head of DR in my firm, and he drafts. It's very clear in his mind what he's trying to say, and that clarity of thought. Well, sometimes I think it's a bit too long for my liking, but it serves its purpose. It's a complete research, and because Yvonne has said it's written advocacy, but and I just want to lastly just highlight that there is also different styles. How you draft written submissions for different courts. Also, you have to imagine that style and that form, but the things like opinions and biases, which again is a completely different ballgame. The reason I don't have slides is because I prefer an interactive thing, because I don't think we're here to read words. I think you can read words. You don't need words to teach you how to draft. I think for me, it's always been a conversation of like a class like this, where I speak to you all speak to me, and then, you know, with live questions that really help, you know, because how you teach someone or how you impart knowledge has to be a two-way process, not just slides. Unfortunately, I'm not old school like that. But and I think I mentioned that to Yvonne when I first took up this engagement, that's not necessarily my practice. But of course, if any one of you here or those who have left for reasons, I'm sure it's a Saturday, please feel free to drop me a line on my email. You can find it on the website or get it from them. I'm sure they have it. If you have anything, feel free to reach out. I wish those of you who are participating in the moot all the very best. And have fun. I think have fun and enjoy what you do. It's an experience. Any experience, good or bad, is still experience. And as long as you prepare, know your case, have confidence, speak slower. I'm generally a fast speaker, so I have in years tried my best to speak slower. So know your weaknesses, know your strength. Those are same with drafting, same with research, same with submissions. Where you are not so good, work on it. Where you're great, crank it up. Okay? Any last questions? Yvonne, Farah, anyone else? No? Okay. It was a great pleasure having all of you. And I hope you walked away with, if not one or two pointers. If anything I said today wasn't clear and you need some sort of explanation, like I said, please feel free to drop me an email and I will be happy to also, if you'd like, you can have a call or something, that's fine with me. Yeah, I'm happy to help. And I wish you all the best, not just in your mood, but in everything you do. Thank you.
Thank you, Miss Anita, for staying with us up until now. That's the end of our webinar session. I believe we have maximized our time together very productively today. And we hope that you have enjoyed sharing your knowledge. And I have certainly gained a lot of insights on written advocacy from this webinar. And I believe that our audience share the same sentiment too. Maybe I can do a short summary from having a clear framework to show the direction of your thought process, to having good index headings, and to always not forget the 3 important rules: law, facts, apply, and making your sentences as short and concise as possible, adding on with Miss Anita's example of her legs and skirts of pressure vessels to illustrate the importance of pictures and diagrams, effective referencing, and lastly, a good conclusion to wrap up your written submission. Keeping in mind to also always do your research and prepare yourself best as you can, especially if you're planning to making a full use of physical resources, not only relying on online ones. But I think the most important takeaway is to remember that we are humans, not robots, especially if you're planning to be a great facilitator and guidance for your arbitrators who will be deciding on your client's case, and most importantly, to win your case. So with that, I hopefully with the good and concise summary of the notes I've made today, Miss Anita, hopefully what I said made me a good law student. Then we will now proceed. We will now proceed to the photography session.
Okay,
and may I request?
Sorry, for our last page numbers, formatting, paragraph, and check. That's the other.
Okay, page numbers, formatting. Okay. So
Okay.
now may I request everybody to turn on your cameras so that we can get a group photo with everybody in it. I'll give you like a few seconds. Thank you. Thank you, Miss Anita. Thanks, everyone.